Welcome to WCS Money Tutorials. Today's topic is, are wealth taxes constitutional? Tax law is complex, consisting of millions of words. Judicial decisions on the tax code consists of millions of more words. Much of this complexity results from the unfairness of the tax code, giving wealthy people vastly more benefits than poor people. Moreover, such complexity leads to unintended consequences, allowing wealthy people to escape even more taxes. A wealth tax, easy to implement and hard to avoid, is the best way to make wealthy people pay more taxes. However, some people say that wealth taxes are unconstitutional. But are they? While the United States Constitution gives Congress the broad authority to lay and collect taxes so that it can carry out its duties, some provisions added some vagueness as to what taxes would be constitutional. Article 1, Section 2 stipulates that direct taxes shall be apportioned among the several states, according to their respective numbers, by adding to the whole number of free persons, excluding Indians not taxed, 3/5 of all other persons. Article 1, Section 8 gives Congress the power to tax and to make all laws deemed necessary for the federal government to function. It also requires that all duties, imposts, and excises be uniform throughout the United States. Section 9 stipulates that capitation or other direct taxes must be proportional to the population of each state. In 1895, the Supreme Court decided that income taxes were direct taxes. Thus, a federal income tax was unconstitutional. The 16th Amendment was passed to nullify the Supreme Court decision, to allow the federal government to collect income taxes from whatever source derived, without apportioning the tax among the states. Definitions of words change through time, so to determine what some of these words meant at the time, I looked at definitions found in Noah Webster's dictionary, published in 1828, though that is still 41 years after the writing of the United States Constitution. The 1828 dictionary defines capitation as a tax or imposition upon each head or person, a poll tax. The problem with the word direct, like most general abstract words, is that it is a very general term that can mean different things in different contexts. However, in studying how the word is used in the Federalist Papers and other historical documents, direct taxes seem to be any taxes applied to people, in contrast to things, such as excise taxes. The 1828 dictionary specifically defines a direct tax as a tax on real estate, such as houses and lands. The Supreme Court decided in 1796, Hylton versus United States, that a tax on carriages to be indirect because it applied to the use of carriages rather than to the property itself. The court defined a direct tax as one that applies to land or directly to humans, without regard to property, profession, or any other circumstance. The tax was upheld in part, reasoning that apportioning such a tax made little sense, because it would have required taxing carriage owners at dramatically different rates, depending on how many carriages were in their home state. In 1895, in Pollock versus Farmers Loan and Trust Company, the Supreme Court held that a general income tax was unconstitutional as an unapportioned direct tax, distinguishing it from a tax on business or employment income, which the court described as a permissible excise tax, an indirect tax. In 2012, in National Federation of Independent Business versus Sebelius, the Supreme Court decided that the shared responsibility payment required by the Affordable Care Act is not a direct tax because, even though it was a tax directly on people, it varied depending on whether the person had health insurance and other factors. This coheres with the 1796 Supreme Court decision that a direct tax applies to land or directly to humans without regard to property, profession, or any other circumstance. Thus, income or wealth taxes would not be direct taxes under these definitions, since income or wealth taxes would depend on the income or wealth of the people. There is no express prohibition against income or wealth taxes. According to the courts, even direct taxes would be constitutional if they were apportioned to the states. However, there is reason to doubt that the Founding Fathers wanted to apply the apportionment restriction to a tax based on value, since such taxes would not make sense. Instead, they were probably thinking about flat taxes, such as capitation taxes, which could easily be apportioned to the states according to population if the tax was simply applied to everyone or to most people. If a capitation tax applied only to slaves, then the apportionment clause would prevent that, which is the probable reason for this restriction. With the apportionment clause, income or wealth taxes could be constitutional, but they would be grossly unfair, because different rates would have to be applied to different states, as you can see from this example. The apportionment clause could make sense if the federal government was envisioning flat taxes per person, rather than taxes based on land value or income, since these types of taxes would have been difficult to implement at that time. Since many Northerners opposed slavery, Southern slaveholders feared that slaves could be taxed out of existence. The apportionment clause prevents that. So, a capitation tax on slaves, such as $1 per slave, would clearly be unconstitutional, since it would place a greater burden on the slaveholding states. This was probably the primary reason for the apportionment clause. While some judges may be okay with applying the apportionment clause to wealth taxes on people, especially since most judges are relatively well off, and so would benefit from interpreting the law that way, there would be no constitutional problem in applying wealth taxes to irrevocable trusts, which are not people. They are separate taxable entities. Many wealthy people use irrevocable trusts to save or avoid estate and other taxes. A wealth tax on trusts is not a direct tax on people, and therefore would be constitutional. There is also no constitutional problem in applying wealth taxes to business entities, such as C corporations and pass-through entities, partnerships, limited liability companies, and S corporations. One type of wealth tax that could help many people is a tax on land owned by businesses. Many businesses buy residential properties to rent out, which drives up the cost of housing for many. These businesses often buy multiple properties in desirable locations, so that they would be the main landlord in that area, allowing them to raise rents even more. Businesses would not be able to pass the cost of the wealth tax on to renters, because they still have to compete with people who own rental properties as individuals. Home buyers would also benefit from lower real estate prices, though sellers would suffer. Having argued the case that wealth taxes are constitutional, the Supreme Court could still declare that they are unconstitutional simply because there are no restraints on its decisions, even if the decision is illogical or not based on facts or law. Nonetheless, if constitutional provisions are unclear, then the Supreme Court should defer to Congress, since the U.S. Constitution does provide that Congress can enact laws to fulfill its mission. Since the wealthy find many ways to shift their tax burden to lower income people by using tax loopholes or even tax evasion, Congress should have the right to enact wealth taxes to rectify this inequity. The Founding Fathers have long since been dead, so they cannot react to the present situation, nor could they have envisioned the future as it is now. Therefore, shackling Congress to vague provisions in an old code should be avoided. Thank you very much for your time. If you liked my video, please subscribe. I would appreciate any suggestions, so please leave them in the comments below. Check out my website at thismatter.com for more than 850 in-depth fundamental tutorials on personal finance, investments, and economics. Check out my books on money at williamspalding.com. Thank you.